Welcome to Leavenworth School District Annual Training. Today we're going to talk about a series of topics today that'll help you throughout the school year and hopefully help you be successful as well as protect you throughout the school year so you can be a productive employee. The slides that I'm going through today are also provided on the website, so feel free to download those, to review those as we go through so you can view all the content on them. Also, you can save them, bring them with you. If you have any questions on any of the things that I covered today, as well as anything in the handbook, always feel free to call your building administrator or central office administration, and they would be able to help you out with that. Also, the handbook is available on the district's intranet, as well as you can get a physical copy from the central office if you need it. So let's get started. The first thing we're going to talk about is I kind of talked about the board policy and our goals and objectives. The purpose of this mandatory training is to ensure that you have the adequate facilities to do your job and that we maintain a safe school environment, not only for our students, but for you, our employees. As we see in Board Policy GAA, which again is available on the intranet or at the central office, all employees are required to follow all the applicable board policies, rules, and regulations. Here is our notice of non-discrimination. Basically, in a nutshell, the district does not discriminate against any employee, applicant, or student based on any of the protected categories, which includes race, religion, sex, disability, military status, etc. This can be found on the district's website as well as at the central office. We'll be talking a little bit more about non-discrimination, harassment a little later on in this presentation. Also, when we talk about non-discrimination, we're talking about Title II of the Americans with Disabilities Act. Again, because the district is a public entity, we do not discriminate against any student or employee based on a disability. If you do need an accommodation, we'll be talking about later about how you get that accommodation, and that the district will engage in the interactive process with you to ensure that you can get a reasonable accommodation if one is available. Also, just as a reminder, that Leavenworth School District is a school, therefore it is a drug-free and smoke-free environment. The board policies that are applicable in this situation are GAOA, which calls a drug-free workplace, GAOB, drug-free schools, and GAOC, which is the prohibition of tobacco in the school buildings. And then finally, you want to look at GAOD, which talks about the district's policy about drug and alcohol testing for employees. So, let's start out with our presentation now that we've gone those highlights about safety and injuries. What we're going to talk about here today is safety within the school on how to perform your job, as well as if you do get injured on the job, what procedures you should follow. So to begin with safety and security, it's always the employee's responsibility to read and follow the district safety manual and procedure. And again, I've told you where you can find those. You can find those on the intranet site, or if you need a physical copy, the central office would be happy to give you a copy of that. And these are some of the policies we're talking about, as you'll see on the slide. We're talking about back injury prevention, classroom and office safety, workstation ergonomics, fire prevention, chemical safety, equipment safety, and slip and falls. Always remember that if you have to operate equipment safely, and only those equipment that you know how to operate and are instructed and authorized to use. Always follow safe work procedures. If you detect or report any hazards or notice of any hazards, always direct them to your supervisor. Always make sure to use all safeguards and safety equipment if that is required as part of your job. And always use the correct tool or piece of equipment to accomplish the assigned job. We do not want you to substitute any improper equipment. Shortcuts are not appropriate and always lead to injuries, which we want to make sure that you are safe in performing your job. If you have to do a lot of lifts, make sure that you know the proper lifting techniques and employ those in each time that you're lifting heavy objects. Also, for fire safety, make sure that you know the locations of our firefighting equipment. Make sure if there is safety instructions handed out by your supervisor that you're following those. All horseplay within the school is strictly prohibited because that almost always leads to injuries. And make sure that while you're in the building, and this goes to teachers and administration, that all doors except the main building entrances are shut and locked during school hours. That is for the safety of not only you, our staff, but for our students as well. Now, what happens, even if following those safety instructions, that you get injured on the job? What do you do? Well, Leavenworth School District employees are covered by workers' comp insurance. So basically, when an employee has a work-related injury and is unable to work, they have certain rights under the workers' comp laws. Now, under our policies, you're able to use your accumulated sick leave and vacation time as outlined in the leave section of our employee handbook while you're out on workers' comp time, if time off is required by workers' comp. Now, when we talk about workers' comp, what are we talking about? We're talking about injuries that occur in the workplace as a part of your duties, okay? So what are injuries that are not integral as part of your job duties, okay? We're talking about things like recreational and social activities. So if you go with a group of employees out on your own after school hours and go to a drinking establishment or a restaurant and you slip and fall, that is not a school-sponsored activity. It's on your own free time. That is not covered by workers' compensation. Again, horseplay we talked about before. Horseplay, roughhousing on school property, even during school time, is not covered by workers' compensation. Similarly, injuries while traveling to and from work are not covered. So if you are coming from your house to the school district to start your shift and you get into an automobile accident, that is not covered by workers' compensation. And then finally, injuries occurring when an employee is under the influence. That means of alcohol, of drugs, etc., is not covered, even if it occurs on school time and during business hours. Now, date of your injury. What happens if you are injured? What should you do? What are the things you should go through? Well, first you need to notify your supervisor that an injury has occurred. And your supervisor will give you an accident form to complete. And those are located on the district intranet, as well as if you don't have access to that or can't find it, always talk to your supervisor or building administration or central office administration. They will provide that for you. That'll give you the information of what you need to fill out of what you injured, what happened, where it occurred, and if any witnesses witnessed it. Your supervisor's responsibilities and those who are district administration, building administration, always make sure to send the injured employee to the school nurse or call 911 depending on the severity of the injury. Our purpose is if somebody is severely injured, that they are treated first rather than having to worry about forms. We're always worried about our employees' health and safety. Next, a supervisor will complete an accident investigation report form and contact the central office to report the injury. Again, the accident investigation report form should be available at all district buildings as well as at the central office if you ever need a copy of those. Next, if needed, we need to schedule an appointment with the approved medical provider by the district. The district has certain medical providers that are approved in advance to ensure that if the employee is injured, that they seek proper medical attention and get the background. Also, we submit a claim to KASB's workers' comp insurance. That's in case any type of monetary compensation or time off comes from there. Now, these are the 4 important workers' compensation forms. Okay, the KASB Supervisor's Accident Investigation Report, we talked about that. That's filled out by your supervisor or building administration. The report by the injured employee, we talked about that, available on the intranet. If you're injured, you complete that, turn it into your supervisor or building administrator. Report by eyewitnesses, in case you identify any witnesses that may have seen you slip and fall, injure yourself, whatever the occurrence, they complete that. And then a patient satisfaction survey, which is often given by the medical provider. If you have any questions on workers' compensation, make sure to contact the business office at the Board of Education at 913-684-1400 or workcomp at usd453.org. Now remember, if you have a work injury, it's imperative that you report it immediately. The district will not retaliate against you if you report a workers' comp injury, nor will it retaliate anybody who participates in reporting a workers' comp injury. Okay, now that we've talked about some injuries, workers' comp injuries, it's a good transition over to the Americans with Disabilities Act and accommodation, as sometimes injuries and disabilities can intersect. So the Americans with Disabilities Act, Leavenworth School District is committed to comply fully with the ADA. And we ensure equal opportunities not only to employees, but also to applicants that apply to the district for employment. And all employment practices and activities are conducted on a non-discriminatory basis, not only regarding disability, but we also talk about, and we will talk later, about harassment and discrimination on other protected categories. Now, any employee who has a qualifying disability is eligible for a reasonable accommodation. If you need a reasonable accommodation or think that you need a reasonable accommodation, that request should be made to the Human Resources Department at the central office. And what will happen then, the district will enter into what's called the interactive process to work with you to see if a reasonable accommodation can exist. Now, as a part of that process, just to understand that the district may require and may need some documentation from your physician or from your doctor to make sure that when an accommodation is sought or looked after, that it covers all the portions of your disability. Similarly, again, any applicant or employee who believes there's been a violation of any district policy or applicable law regarding disability, and that includes accommodation, that includes discrimination, it includes retaliation, should immediately report that to Human Resources. Okay? We will follow through and make sure that nobody is discriminated based on a status of having a disability. Similarly, there will be no retaliation. So if you have an accommodation that you think you may need, you report it again to the Human Resources, and you will not be retaliated against for seeking a reasonable accommodation or helping somebody else seek a reasonable accommodation. Again, if you have any questions or have any complaints of discrimination, retaliations, or need an accommodation regarding a disability, contact Human Resources at the Board of Education at 913-684-1400 or by email hr@usd453.org. Okay, so now let's switch gears a little bit to confidentiality. When we talk about confidentiality today, what we're going to talk mostly about is student records and student data confidentiality, although we'll talk a briefly small amount about confidentiality of certain employee files and information. The extreme care should be used to ensure the accuracy and confidentiality of all student grades, attendance, and other records. It's very clear, I think we're all familiar with that student grades, attendance, other records, other information can only be revealed to certain individuals by law. The Student Data Privacy Act is one law that covers this. It's also referred to as the SDPA. There's a lot of information on this slide. Please go through it and take your time with it. But basically what it does is it provides restrictions on what data contained in a student's file can be disseminated and to whom it may be disseminated. Okay? It permits it to be disseminated, for example, to the student or the student's parent or legal guardian at any time. However, the law does require also that it be disseminated to certain personnel of an education agency, similar to like the Kansas Board of Regents, and also allows the information to be disseminated between agencies to help each other out if they have a data sharing agreement. Now, on top of that act, we have the Family Education Rights and Privacy Act, also called FERPA. You may be familiar with this. And that's a federal law that protects the privacy of students' educational records. And the law applies to all schools that receive funds under any applicable program of the U.S. Department of Education, which Leavenworth School District obviously does. Therefore, we are covered by FERPA. Now I want to talk a little bit, just briefly, on HIPAA. And HIPAA will apply not only to our students, but potentially also to employees. And what HIPAA is a federal civil rights law that protects your fundamental rights of non-discrimination and your health information privacy. And when I talk about health information, we're talking about, for example, if you have to turn information in under FMLA or under your disability, as we talked about, that the district will keep that information confidential. Similarly to students, if a student is seen by a school nurse, we are required to keep all that information private and non-disclose it. Okay, now let's talk about staff and student interactions. And we're going to talk about this. Some of this may seem very silly to you, but again, some of the things I'm going to be talking about here, while they may seem extra steps for you to take, are really for your protection more than anything else, particularly with some of the news items and going on about claims against teachers and inappropriate conduct between teachers and students. What our goal is to protect you from those claims, or if a claim is made, that you have the proper tools and documents to show that no inappropriate behavior was occurring. So, first we're going to go through some board policies. Bear with me as we go through that. Our board policies say, except in exceptional circumstances, staff members should only utilize district-provided means of communication when communicating with students or performing their job. Now, I will go into this a little more in detail here in a second, but again, it's very important to do that. Why? First of all, that district-provided communication can be searched by the district. So, if a student claims that they have received an email from you of an inappropriate nature, if you've used the district's website and the district's email system and their electronic communications, we can pull those up to the original form of that email to see if the email the student provides has been manipulated in any other way. So just one example. Also, we provide examples and opportunities for you within the email system on the district to save those emails. So if anything ever has to go back, it's always there. It's easier to get back emails on the district system than through a Gmail system if you've deleted it. It's almost impossible to get through, a long, huge process to do that. Now, policy GAF, as I'm sure most of you are aware, says staff members shall maintain professional relationships with students which are conducive to an effective educational environment. Pretty self-explanatory. I think all of us know that and know what those expectations are. Staff members shall not submit students to sexual harassment or racial harassment. Now we're going to talk about harassment in the workplace as far as employee to employee, and those same principles really will follow with students as well. Again, continuing in policy GAF, staff members shall not have any interaction of a sexual nature with any student at any time, regardless of the student's age or status or consent. So that means if a student is 18, a senior in high school within our district, even if they are 18, which is a majority, that they are considered an adult, and even if they consented, that is not allowed, not appropriate, and any teacher found violating this portion of the policy will be subject to discipline up to and including termination. Now, policy GAAC talks about sexual harassment and talks about sexual harassment will not be tolerated in the school district in any manner. And when we talk about sexual harassment, if you read the policy, it includes not only employees, but it includes students of the district. It includes our certified and support personnel as well, and includes any business or other contact within the school. Okay, so that could mean visitors, vendors. Okay, that those are the type of people. No sexual harassment is permitted at all. Continuing GAAC, sexual harassment includes, but is not limited to, unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. Now, when we talk about other verbal or physical conduct, verbal, joking, anything that's uncomfortable, those type of things. Make sure when students that you are watching what you're saying to students. Remember their appropriateness of their age. Some students are going to get certain jokes or not certain jokes. Always be err on the side of caution when you're talking with your students, no matter what age they are, to ensure that that line isn't being crossed, and again, that protects you. Continuing with GAAC. Any employee who witnesses an act of sexual harassment, this is to a student or even to an employee, or receives a complaint of harassment from another employee or student, shall report the complaint to the building principal. And I will go even beyond that to say that if you're uncomfortable with the building principal, or if the building principal is the subject of the harassment, you bring it up to the Board of Education. And if you're not comfortable with the Board of Education, or the central office, then you go up to the Board of Education. Employees who fail to report complaints of incidents of sexual harassment to appropriate school officials may face disciplinary action. And on top of that too, remember that this crosses over into mandatory reporting status as well. That if a student is being taken advantage of and you are aware or have a suspicion that it may be occurring, you do have a mandatory requirement to report that. And we're going to talk about mandatory reporting here soon. Now, with always these great things of these news articles going on about students complaining or making allegations against teachers, I think a lot of teachers and a lot of school officials are afraid sometimes, well, how do I interact with students? What's acceptable, what's not acceptable? And it might sound silly, but let's go over just some brief acceptable encouragement. Verbal praise in a positive nature, always acceptable. High fives, thumbs up, pats on the back, appropriate encouragement notes on a test or homework is always great. And then for those of you who are in athletics or in coaching, acceptable training and spotting is, again, also appropriate because there the touching is required to ensure that the student's health and safety is maintained. Now, interactions. What happens when you have to meet with a student? And more specifically, what happens when you have to meet with a student on a one-on-one basis? Well, when you have to meet a student with an individual basis, first, I don't like one-on-one interactions. If you can have another adult present, that is much more safe because you have another witness. Also, with our phones, there is no reason if you feel that that something may happen within the meeting itself, you can always record the conversation and save an email to yourself on the emails district website, keeping a conversation or some record of that conversation just in case, again, a student makes an allegation that something inappropriate occurred. Never meet behind closed doors. So even if you have to meet with a student one-on-one with no one else there, always keep the door open. Even if it's on a private matter, something like that, we want to keep it open, have the setting appropriate. If you need a meeting place on a one-on-one and the schoolroom is too busy or the halls are too busy, contact central office, and central office will either help you find another place or your building administrator too will see if the building office has a place that you can meet. If appropriate, notify the parent and your supervisor or building administrator. Okay? Notifying a parent, particularly let's say if you're going to meet with little Johnny after school to go over math problems, notifying the parent so that they're aware that you're meeting helps at least communicate properly that you're meeting with the student so that there's no surprise later on. Also, keep notes of an individual meeting with students. So, if you're meeting with a student, put it in your calendar. After you've met with the student, write just a brief summary, either in paper format or email yourself an email and keep it into an email folder within your Microsoft Office that talks about what went on in the meeting, who was there, what time it started, what time it ended, what topics were discussed. Also, always limit your interactions with students to school or education-related activities. Refrain from taking students to outside activities that are not sponsored by the school. So, taking a student to a movie just because. Stay away from that. Be attentive to all communication made to students outside of school. Now, what are the things we think about automatically? We think about, calling the student, emailing the student. But this also is considering social media, which we know is exploding and is a huge part of all our lives right now. I would say, I bet to guess that at least 90% of you have a Facebook account or a Twitter account or Instagram account, or maybe all three. Those communications, while the district cannot prohibit you from friending your students and communicating through them outside of school hours, be very careful with those social media accounts. I could talk about all day about cases where social media accounts have ruined careers based on what a student has posted on a teacher's website, or it's been posted on a teacher's website that a student then copied and sent out amongst their friends. So be very careful with that. My recommendation as a district's attorney would be to not friend any students, particularly in your class, and frankly would not friend anybody under the age of 18 unless they're a close family friend, relative, something like that. And again, also be attentive to physical interactions with students in and outside of the classroom. Now we move over to another policy, GAFA. And this again, it's a little rehashing of the same, but just want to make you aware of the policies that talk about these interactions. And it talks about the relationships between staff members and students shall, again, at all times foster an effective educational environment. We've talked about that. And the relationship shall never be harassing, discriminatory, retaliatory, or soliciting, and shall be professional and not personal. Now again, just another policy. This is how important this is to the district, that we have multiple policies covering this situation. Staff members are always responsible to maintain that the relationship is professional and educational. It's never the student's fault. If the student ever crosses a line to you, then it is your responsibility to contact building administration or central office administration so that can be remedied immediately. Staff members are primarily responsible for the success of the teaching and learning process. That's why we hire you. You are all qualified. We are glad you're here. We put our students in your hands, knowing that they're going to be molded and taught. Now, part of your responsibility, again, is maintaining communications with your students on an individual level in order to assure that students are receiving the necessary and proper instruction. And we understand and recognize that electronic communication is one avenue with that. And some of you are doing wonderful things with electronic communication and setting up certain Facebook accounts as a class type of thing, email chains and stuff like that. As long as it's monitored, as long as the school district is aware of it, and as long as it is maintained in an appropriate professional manner, that's fine. But again, always protect yourself. Okay? Nothing put on the internet is safe anymore. Nothing is ever deleted. We know about this. So any type of backups you can do, any type of protections you can do for yourself is going to protect you against any future claims that a student may make against you, particularly those false claims. Again, electronic communications, what are we talking about? We've talked about email, we talked about social media, but that also includes text messages, instant messages, instant messaging, posting messages on a social network page, or even this wonderful new thing called Snapchat, which I am not in favor of, but a lot of students are using it and it's very dangerous. When staff members communicate with students via email, again, it should always be through the district's email system. And again, I know I've hammered this over and over and over, and you're probably tired of me saying it. But again, it protects you. When you use and limit all your communication with your students through the district's email system, you are creating a map. You are creating a history that can be pulled up at any time. Kids are smart. They can manipulate emails. They can manipulate posts and then do a screenshot on their phone or screenshot on their computer. If we have the originals that we can pull off our email system to show that, hey, here's what the whole chain is, a little Johnny cut out this part or changed this part, then we are protecting you. Always, if possible, use the district's communicated electronic systems. It is recommended that staff members shall save a copy of all email communications sent to students through the district system in a folder called Email to Students. Now, I will tell you that I'm a folder fanatic in my emails and system and my Outlook. What I would suggest is when you have an email students folder, then underneath you break it up by class period, you break it up by class name. If you have to go and by student name, if you need to go and send regular emails to another student, just so it's easily trackable and easily to find. Again, any communication sent to students through the district's email systems or any other systems, particularly when during school hours, should always be on proper educational purposes so that it complies with the other policies we've talked about. Staff members are prohibited from sending personal email or electronic communications of a personal nature to students during your time at school. Okay? Now again, I've talked about outside of school, the district can't prohibit you necessarily from communicating with students. However, it's recommended that you keep everything on an educational basis. But when you're on duty during school time, you cannot have personal communications, especially electronic or email, with a student. And all staff member communications to students should always be strictly related to the student's educational coursework or school-sponsored activities. Now, sometimes there's an event going on and a staff member may have to transport or take a student on a certain event. What are those procedures? Can they do that? Yeah, they can. A staff member is allowed to leave school grounds with a student or meet a student off grounds, depending. I know sometimes we have some smaller events out there that don't require big buses of students going on. I know Power and Light, the show choir, for example, is a smaller number of students. Sometimes it's just an individual student or student on ROTC. I know we've had some great successes in the last couple of years on some of those marksmanship activities and competitions. So what do you need to do? Well, first, it must be for professional reason only. So again, a school-sponsored activity, a competition, something to deal with education. 2, it must be approved in advance by the principal and the parents. So no last-minute type of things without the school and the parents knowing. Again, this is not to add more processes or red tape for you, it's to protect you. The more people that know, the more protection you have. Now, if you're driving and you have to drive and transport, remember you have to have auto insurance on file with the school district. So if you're transferring a student, even if it's in your own car or if it's a district vehicle, you have to have your insurance on file with the district. And finally, if you are driving and you're transporting a student by car, remember that you're the only one to drive. The student is not to drive, even if they have a valid driver's license. Okay, so we've talked about communication. We've talked about sexual discrimination and harassment to students. Remember, I talked about this mandatory reporting, that if you witness sexual harassment by a student or suspect it, that you have talked about mandatory reporting and you have a requirement. Well, let's go into those requirements and talk about those in a little more detail. So mandatory reporting is required by state statute. It's a requirement for people who work with students, and it's a requirement of all district employees. And what it requires is that district employees report suspected abuse and or neglect. Now, the key word in that is the word suspected, okay? It doesn't have to be proven. There's no beyond a reasonable doubt. There's no reasonable suspicion. It's just suspected abuse or neglect. If you suspect it, then you have to report it. Also understand that if it's suspected abuse, that you don't have to have contact with the family directly. There's no requirement for you to first go and reach out to the family. Instead, what you should do is, if you have a report, you can report it to Central Office Administration. You can report it to your building administrator. Also, you can call 1-800-922-5330, which is the Kansas Protection Report Center, PRC, and they have a hotline 24/7, which accepts those calls. Also, if you feel it's very dangerous that needs immediate attention, never hesitate to call local law enforcement. Now, I talked about the statute. Just so you believe me, it's KSA, Kansas Statute KSA 382223, which talks about when any person within the district suspects that a child has been injured as a result of physical, mental, or emotional abuse, neglect, or sexual abuse, the person shall report the matter promptly to DCFS and/or law enforcement. Now, Kansas Statute KSA 39-1431 also says that if you suspect abuse, neglect, exploitation, or fiduciary abuse of any mentally ill, incapacitated, or dependent person, again, you should report to DCFS or law enforcement. So 39-1431 is talking about our special ed students. 38-2223 is talking about our regular ed students, okay? But again, remember, the standard is still the same. Suspected neglect, suspected abuse, okay? Don't feel like if you have that knot in your stomach that you feel something's going wrong. I and Central Office and the Board of Education would rather you go and err on the side of caution, of going and reporting it to ensure that that student is being taken care of and that they are not being subjected longer to any type of abuse or neglect. And remember, within these, it talks about sexual abuse. We're talking about back to that sexual harassment by another teacher or any type of school employee. Now, employers are prohibited from retaliating against any teacher or any mandated reporter who reports suspected abuse and neglect. And Leavenworth District takes that very seriously. We do not prohibit retaliation. We do not permit retaliation against any employee who follows their duties under the law of mandated reporting. Now, when you do report, some agencies expect staff to discuss the abuse or neglect with the building administrator or the district beforehand. Now, the school district obviously would like to know about things before, but remember, it's still your duty to report. So if a report, for example, is against a principal or someone at the central office, you do not have to report to them first, but you still have to report the incident. You are not excused from your reporting responsibilities just because you feel uncomfortable first telling a building administrator. Now, violation or not following through with your mandated reporting responsibilities can result in a Class B misdemeanor. Now, as far as confidentiality of these reports, Kansas law provides that the identity of the reporter not be disclosed. So if you report under the mandated reporting statute, your identity will be not disclosed, except for a couple specific instances. First, if the case is heard in court, or if an SRS finding is appealed and heard at an SRS administrative hearing, there's a possibility that the reporter's name may be disclosed in those proceedings. Okay? Similarly, if a judge during some type of court proceeding requires or orders that the reporter's identity is disclosed, again, it'll have to be disclosed. Despite these situations, and despite sometimes someone's uncomfortability with leaving their name, it is invaluable. I can't stress this enough. Invaluable that a person leave their name and contact information. And what that does is it allows for follow-up questions, It allows for a full investigation to be conducted so that if there is abuse or neglect happening to a student, that the proper course of action can be taken. That's what we want. We want to protect our students. That's why this is here. That's why there. So while the law requires and allows you to report without identifying yourself, and you are more than free to do that, and we're able to do that, understand that when you do leave your name, it can help the investigation and help protect those kids. Okay, so next let's talk about our acceptable use policy, which is a policy I'm sure all of you have signed and looked at. And what we're talking about is the use of the district's electronic resources. So, staff will provide appropriate supervision to students using district technology equipment. So again, making sure that you supervise what students are using, how they're using the district's provided electronic communications and resources. As we know, our district is very, very lucky to provide our students with a plethora of electronic devices, including Chromebooks we've done in the past, iPads we've done in the past, etc. Communicate your electronically with students only with district-provided and monitored equipment. We've talked about that at length. Again, it's for your protection. And again, use district technology in accordance to the educational, administrative, or job-related duties, with an exception for personal use on an occasional basis. Okay? So, are you going to be disciplined if you go and you check out your Facebook once during the day to wish your best friend happy birthday? Of course not. But again, all our equipment and our resources should be used primarily for the educational basis for our students or for the job that you are assigned. Staff will not, and this is an absolute bar, sharing passwords with others. Don't do it. Do not download, store, or share any software or file in violation of copyright law. So no stealing, no taking clips from other websites and using them improperly. Do not intentionally access material that would be inappropriate for school. I think we all know what that is. We're talking about anything that would be crude, lewd, harassing, that would include pornography, inappropriate jokes, anything of that nature. And finally, staff will not intentionally damage, disable, or hinder performance of any district system, device, software, or network. So that means no throwing your iPad across the room, even if your students are acting up, no downloading viruses, or downloading any documents or programs that may contain a virus. All right, let's talk about discrimination and harassment laws. Okay. Now we've talked a little bit about the ADA already. We've talked a little bit about discrimination, harassment of students. Now let's talk about employee-to-employee discrimination, harassment. And understand that a lot of these definitions also apply still to the student and an employee situation in those relationships. Now there's a plethora of laws here that are covered when we talk about discrimination or harassment. We're talking about Title VII. Title VII covers your religion, your race, your color, your national origin. ADEA covers age. ADA covers Americans with disabilities. PDA is your pregnancy. EPA is your Equal Pay Act. NLRA is your National Labor Relations Act, which covers those individuals that are part of the union or teachers union. USERRA covers our service members. And then KAAD is the Kansas Act Against Discrimination, which really almost encompasses all of those federal statutes. So what's prohibited when we talk about discrimination or harassment? We're talking about differential treatment, which I call basically intentional harassment, okay? So you can't go in and say, I am not going to give you a raise because you're black, or because you're Jewish, or because you're a woman. That is intentional treatment, intentional harassment, okay? That is prohibited. Seems easy. Disparate impact is what's called unintentional. So what does that mean? That means, let's say the school district had a rule that said we will only accept teachers if they are 6 feet or taller in height. Well, that has a disparate, while the rule on itself doesn't discriminate against anybody on its face, it has an unintentional impact against women because most of the individuals who are over 6 feet in height are men. So something like that would be prohibited. Again, harassment, which we'll talk about, and then retaliation is prohibited. So what is unlawful harassment when we talk about harassment? It is conduct that's based on a protected category. Okay, so protected category, again, meaning race, religion, disability, sex, color, national origin, military status, union status, etc. That is unwelcome or offensive, is severe or pervasive, and is a condition of employment or creates a hostile work environment. So what are the protected categories? I think I named all of those and rattled them off. They're here for your reference. Again, sex, gender, pregnancy, race, color, national origin, ethnicity, religion, age, disability, military status, and union affiliation. And as the laws progress, more may be added to this list, but the district's policies will always be updated to include the most recent protected categories. So once you figure out already, do you fall under a protective category? Next is the conduct unwelcome or offensive? So we always consider, what does unwelcome or offensive really mean? Okay, I come up with 2 tests, and if either of these 2 tests are no, you answer no to either one of these questions, then you probably shouldn't say or do what you're going to do. So the first one is, would I behave the same way if my spouse, child, parent, or grandparent were standing next to me? If the answer is no, then you probably should either stay quiet or refrain from the activity. Now, for those of you who are so emblazoned and would go and do anything, I have a second test. And the second test is, would I want someone else to act this way towards my spouse, child, parent, or grandparent? And again, if the answer is no to that, then you shouldn't. Now, what is a hostile work environment? Now, it's imposed by any harasser. And when we talk about a harasser, we talk about a supervisor, a coworker, a citizen, a vendor, or any third party. Okay? So even a vendor who goes and drops off the soda in the soda machine, you are to be protected from harassment from that individual. Okay? And it's any type of conduct that's intimidating, abusive, offensive, or creates a hostile atmosphere. And it has to unreasonably interfere with your work performance and ability to perform your job. Now, common examples of sexual harassment include touching of a sexual nature. I think we all know what that is. Sexual advances or propositions, I mean even asking someone out on a date repeatedly and getting no. That could be considered sexual harassment. Flirtation or suggestive comments using innuendos, requests for dates after being repeatedly rejected, again, sexual jokes, innuendos, labels, and stereotypes. And again, when we talk about sexual harassment, the traditional thing is to think about verbal or cartoons posted on the wall or those type of things. But now with social media and everything else, we're talking about anything that could be potentially on Facebook if you say something wrong, anything through an email, a Snapchat, a text message, anything like that. Now, examples of non-sexual harassment, but harassment that is still covered under a protected category. Labeling based on a protected category. So stereotypes, when we're talking about stereotypes, we know different stereotypes based on different protected categories. Jokes based on a protected category, or derogatory comments about a protected category. While these are not sexual based, the same type of principles still apply to all the protected categories, okay? So whether, again, that's religion, whether that's race, whether it's national origin, whether it's union affiliation, military status, any of those, they have the same protections against harassment as sex and gender. Now, what happens if you come face to face with harassment? Now, this is even occurring to you or you witness it. What happens? You report it immediately. That's what we want. We will not tolerate harassment or discrimination in any manner. You must report it immediately. On top of that, use reasonable care in avoiding harassment. And what does that mean? when I say avoid using care, if someone's telling an off-color joke, you need to not participate or stay silent. Tell them to stop. And if you feel uncomfortable telling them stop, tell your supervisor or building administrator or central office administration. The board's policies that cover harassment are listed here under the G category, J category, and under K. They're all provided on the district intranet site. If you want physical copies of those as well, contact central office. Would be happy to get you hard copies. And then also, if you report, again, we've talked about this. You should report because you should have no fear of retaliation. No adverse employment action will occur or will happen to you because you meaningfully and in good faith report what you think is sexual harassment or any type of harassment. Complaints of harassment should be made either to your direct supervisor, it can be made to the district compliance coordinator, or the Board of Education. Our district compliance coordinator is the superintendent, Mike Roth. He can be contacted at the Board of Education at 913-684-1400 or at mike.roth@usd453.org. Remember, if you make a complaint, or even if someone makes a complaint against you, there's no retaliation allowed. Employees have the right to report harassment without fear of reprisal. And that not only means against someone who's in an administrative capacity, but that also means from fellow teachers or fellow employees. The district will not tolerate harassing or bickering or shutting out or blackballing somebody who made a reasonable complaint based on the information that they knew. Employees have the right to participate as well as witnesses in investigations without fear of reprisal. So, if you get called in as a fact witness for a discrimination complaint or harassment allegation, please feel free to participate fully, because we want to be able to ensure that all our teachers have a safe place and a place that they are comfortable working in. And sometimes that will only happen if people will stand up and give the facts that happened, that what they know, so that any type of harassment and discrimination can be immediately stopped. Now, accommodations. We talked about disability accommodations. Well, there's also another accommodations that are also equally as important, and that's religious accommodations. Okay? So now, under religious accommodations and disability, if you need an accommodation under each, again, all you need to do is contact the central office and the HR. Okay? Administration will meet with you and engage in the interactive process to determine if a reasonable accommodation exists. And as we talked about with disability, there may be some requirements on you to turn in some doctor's form or some type of documentation showing of what accommodations may work or what some limitations may have, so that we can determine whether an accommodation exists and can be given. Again, to go on with the retaliation theme, no one will be retaliated against or punished in any manner for seeking a reasonable accommodation, either religious accommodation or a disability accommodation. So we've talked about harassment, okay? And there's a big difference sometimes between harassment and what we call bullying. Now, harassment, again, we talked about is a protected category, okay? So I, myself, as a KU grad, can make fun of all the Missouri people all I want, because going to Missouri is not a protected category. It may not be a smart choice, but it is not a protected category. And I'm sure those Missouri people would be happy to make fun of me for the same thing. But when we talk about bullying prevention, what are we talking about? Now, the current Board of Education policy for preventing bullying is JDDC. Now, this also links to several other policies that we have in effect that talk about generally for harassment and other items, and those are GAAB, JCE, JGEC, JGECA, JDDC, and finally EBC. So, what the Board of Education prohibits is they prohibit bullying in any form, including electronic means, on or while using school property, in a school vehicle, or at a school-sponsored activity or event. So what does this mean? If you are on work time checking your Facebook account, you cannot participate or post something that would be considered in a bullying manner on someone else's Facebook account. Why? Because you are on school property, using a school computer, and it is during school time. Bullying means, under our definition, and under the state's definition, an intentional gesture or any intentional verbal, written, electronic, or physical act or threat, either by a student, staff member, or parent even, towards any student, staff member, or parent, that is sufficiently severe, persistent, or pervasive that creates an intimidating, threatening, or abusive educational environment that a reasonable person, under the circumstances, know or should know will have an effect of 1. Harming a student or staff member. That's either physically or mentally. So again, what we're talking about is any type of communication that anybody would know would adversely affect. Now, we're not talking about, again, the dialogue between a KU and MU or K-State and KU or whoever, the friendly banter. We're talking about communications that becomes a harassing manner, a mean manner, almost an attack on somebody that falls even outside the protective categories. Because we've talked about the protected category harassment, we were protected there. This is something more. We all know about bullying. So it's that type of communication. And what the person is, the communication has the intent of, the person knowing that it'll first harm a student or staff member, damaging a student or staff member's property, placing a student or staff member in reasonable fear or harm, and that reasonableness is considered not only in the staff member but also a reasonable person standard, and placing a student or staff member in reasonable fear or damage of their that member's property. Okay. Bullying also includes cyberbullying. Now, this has been in the news rampant all over and somewhat pretty close to home considering the case in Missouri with a teen suicide based on negative comments and bullying comments on Facebook posts. Cyberbullying is specifically covered by the statute and by our policy. And what cyberbullying means is bullying by use of electronic means. So that means email, that means text messaging, that means Facebook, that means Twitter, Instagram, Snapchat, all of those. We do not tolerate bullying by students, staff, or parents in any form. We do not, we will not, we never will. It's not appropriate. It doesn't help our students to have an environment that they feel safe to come and learn, nor does it help our staff that we want them to have a comfortable place for them to come in so they can do their job and cultivate our students' minds. No teacher, administrator, or school district shall engage in, permit, or tolerate bullying. If you witness it, immediately report either to your building administrator or central office administration. Okay? Even if you're not the subject, you need to report. Now, what we cover this too is those people who stand alone on the side and witness and don't do anything. Okay? Just because you may not be saying something directly, if you laugh, are participating, the heckling kind, you are still participating. We will not tolerate any of that type of conduct. Again, retaliation against any victim or good faith reporter or a witness to bullying is prohibited. Student or staff member who engages in an act of bullying, reprisal, or retaliation or false reporting will be subject to discipline in accordance with school district policy and procedures. So for employees, that could be written discipline, it could be up to termination, depending on the severity of the situation. So again, I want to talk about that. Talk about the bullying itself, any reprisal or retaliation, that if somebody reports you, that you go after them or bully them or harass them in some manner. That's not or false reporting. If you're going to report, we just want to make sure that it is a true report and it's made in good faith. School administration and our board may take into account the following factors when determining appropriate discipline, okay? And this is a little mix of students and of staff. First, the ages of the parties involved, okay? There's a difference between if a parent is bullying someone else's child. We take that into consideration. Between two staff members, depending on whether they're the same age, whether one's older or younger, what's the classification on that too? The maturity level and development. Again, that mostly goes to students, but can go to some adults. Special education needs of the parties involved, which then we start getting potentially into IEP 504 plans and those type of things, and whether recertification has to occur. And the severity of the behavior. So is it a one-time mean text, or is it somebody came through and keyed someone's car with something awful and embarrassing and destroyed their property? Okay, so we've talked about disability in the past. We've talked about an accommodation. Well, what happens if you don't necessarily have a disability and you may need time off, or you have a family member that may need time that you need to take care of? Well, the district has FMLA leave, which we provide for our employees. Now, to be eligible for FMLA leave, the Family Medical Leave Act, you have to have worked with the district for 12 months, and you have to have worked at least 1,250 hours over the previous 12 months in order to qualify. So once you've met those two baseline requirements, then we have to look into to see if you're entitled to FMLA because of the condition or the medical condition. And FMLA describes it as a serious medical condition. It covers a wide variety of things. So first, it covers incapacity due to either pregnancy, prenatal medical care, or childbirth. And that's not only for our female employees that are carrying the child, but also to their partners who may need to care for them. So if we have an employee who has a partner who is pregnant or is on bed rest and needs someone to take care of them, and our employee is the only one who can do that, then they can take FMLA to care for that person. It also is there to care for the employee's child after birth or placement after adoption or foster care. So if you have given birth or your spouse has given birth, you do have the opportunity for FMLA to care for that child, or the same thing with an adoption. Also, an employee can take FMLA to care for that employee's spouse, son, or daughter, or parent who has a serious health condition. And also, the employee can take leave for a serious health condition that makes the employee unable to perform the employee's job. Now, on top of FMLA leave, FMLA has been recently, within the last 4 or 5 years, modified to also include some military family leave entitlement. And what this covers is eligible employees with a spouse, son, daughter, or parent on active duty or an active duty status in the National Guard or Reserve, so they've been called in support of a contingency operation. They may use their 12-week entitlement to address certain qualifying exigencies. And if you have questions about that, you can contact the central office and they'll discuss that with you. Also, eligible employees may use 26 weeks of leave to care for a covered service member with a serious injury or illness incurred in the line of active duty during a single 12-month period. Okay, so they've expanded that out if you have an eligible family member that has an injury due to active duty status. What are your employee's responsibilities in order to obtain FMLA leave? First, the employee must provide 30 days advance notice if they need to take FMLA leave when the need is foreseeable. Okay, so what's an example? If you're pregnant or you have a spouse that's pregnant and you kind of know their due date, you need to at least give us the anticipated time at least within 30 days. Now, when 30 days notice is not possible, the employee must provide notice as soon as practical. So for example, if your spouse is due on June 1st and you give the district notice on April 1st that, hey, look, here's the due date, and then suddenly, under unforeseen circumstances, your spouse goes into labor earlier, all you'd have to do is give reasonable notice beforehand to say, hey, look, baby came early, we're going through, we need leave. The FMLA process is about 6 steps. First one, the employee, you have to report to your supervisor or HR to request for leave time. HR is the most direct route. Step 2, the supervisor or employee will complete the FMLA request form, which are located on the district intranet. If you can't find those forms, please contact the central office. We're happy to provide those to you. Step 3, you send your FMLA request to Human Resources, which we review. The district will mail your FMLA forms to you for you to complete. Some of those have information from your physician, which has to be completed. Once you receive those forms, you have 15 days to submit the forms and the necessary paperwork back to our benefits assistant. And then finally, you'll be contacted about your leave status by mail. And you can always contact HR verbally too if you have not heard back. The employee is required to provide their supervisor and assistant HR director updates on your intention to return back to work once you're on leave, okay? So if you're on leave, you have to let us know about the time when you're coming back so that we have an expectation of when you're coming back. Employees must also submit a fitness for duty before they can return back to work to ensure that you are able to come back to work off your FMLA. If you have any questions on FMLA leave, paperwork, or anything like that, please contact Human Resources at the Board of Education at 913-684-1400, or you can contact them by email at hr@usd453.org. We're in the home stretch now, so let's talk about emergency safety interventions, or what's called ESI, for all students. So what is ESI? Basically, we're talking about physical or certain types of restraint or isolation of students based on an emergency situation, really when they pose a danger or threat to themselves or to another student. So when we talk about emergency, we're talking about immediate danger and imminent danger, and a response to an emergency situation by use of seclusion and or restraint when less restrictive measures cannot de-escalate the situation. Safety, we're talking about the immediate danger of the student harming themselves or others. And the I, intervention, we're talking about the restraint or seclusion should only be used for limited periods of time, and they should cease immediately when the immediate danger of harm to the student or harm to others has dissipated. Prohibited seclusion. Seclusion is prohibited if the student is known to have a medical condition documented in a written statement by the student's licensed healthcare provider, stating that any type of seclusion or certain types of seclusion are prohibited. And all those statements and documentation must be kept in the student's file. So let's talk about what seclusion is. Seclusion is not necessarily place, but what we're talking about this is more of a process identified by 3 criteria. Okay? The student is first placed in either an enclosed area by school or personnel. Okay? That we have special rooms for certain classrooms for that. Either or purposely isolated from adults and peers, so they don't even have to be in a separate room, but isolated in a different part of the room. Or they're prevented from leaving, or the student themselves reasonably believes that they can't leave an enclosed area. Seclusion can occur in any location. However, if there is a room dedicated for seclusion, certain regulations have to apply. Now, this lists some of them in more detail. If you look at the district's policies about seclusion and ESI, that gives you more detailed information. I would encourage you to read that policy in its fullest so you are fully aware. But if there is a room, it has to be The seclusive settings to be used for any particular student should be a size that is appropriate for that student's chronological age, as well as their height, weight, behavior, etc. The ceiling height can't be unusually low. It has to be comparable height of the ceiling around it with the other rooms. The seclusive setting also has to be equipped with heating, cooling, ventilating, and a lighting system, which again are comparable to the rest of the building and the rooms located around it. Each seclusive setting should be free from any object that poses a danger to the student who's placed in the room. And any seclusive setting should be equipped with a door that is locks only if the lock is equipped with a device that automatically disengages in case of emergency, such as a fire and a tornado. So a key lock on a door is not appropriate because it cannot automatically be disengaged in an emergency situation. Now, monitoring. What if you have to put someone in seclusion? Students must still be monitored by district personnel who are in close proximity, and they have to be able to see them and hear the student at all times. Very important. Monitoring also should be face-to-face unless the personal safety is significantly compromised. And in that case, technology support can be used, for example, video cameras, etc. Now again, seclusion must be ceased immediately once the emergency situation is passed. Seclusion is only allowed during times and for the length of a time till the emergency situation has dissipated and ended. If you have to use ESI, building administrator should be notified at any time when they're placed in a seclusive setting, and 15 minutes after the initiation of the seclusive setting. Time in a seclusive setting shall not exceed 40 minutes with reassessment of the situation to include administrative staff. And again, building administrators are expected to check on any student in a seclusive setting once they've been notified that ESI is being used. So there are really three kinds of restraints. Restraints can be either chemical, mechanical, or physical. Now, chemical restraint is prohibited within our district. Now, the only exception to that is if there is an IEP or 504 plan in place that allows certain medications to be given to a student, okay? So the use of medication to control students' violent physical behavior or restrict is prohibited, except as, again, prescribed treatment for the student's medical or psychiatric condition by an appropriate licensed physician, okay? And that'll have to be under the IEP or student's 504 plan or some type of medical document. Mechanical restraint, we're talking about devices that prohibit a student's movement, so strapping them down to a table, strapping them to a chair. In this district, it's prohibited. Now, physical restraint, we're talking about using body force to limit a student's movement, is allowed, but only by our trained personnel. So physical restraint, when can it be used? It can be used in an emergency situation, as we've talked about. It also can be used when less restrictive measures have not effectively de-escalated the situation. So that really comes into that emergency type of situation. So we're talking about emergency, we're talking about life, limb, threat to harm to self or to others. Less restrictive measures, we're talking about something where we've tried, it's not necessarily an emergency, but we've tried to de-escalate the situation. Still may cause a harm, but we've tried non-physical contact, we move to that. And then finally, if an IEP or 504 plan, assuming it's parental approved, that is another instance where physical restraint can be used. Now, physical restraint is used. It can only be used, again, for as long as necessary to resolve the issue or prevent harm. No greater force than necessary can be used, and no pressure or weight can be placed on the student's chest, lungs, sternum, diaphragm, back, neck, or throat that would restrict breathing. Okay? And finally, it can only be used by trained personnel. Now, documentation. Anytime you use ESI, physical restraint, anything like that, documentation must be completed. The district has ESI forms. Again, if you need one of those forms, we will make those available to you. You can contact central office or your building administrator. Along with the ESI forms, parent notification has to occur. Now, if you read the district policy, it goes into detail on what information must be provided to the parents. It's very detailed, kind of a who, what, where, when, why, how long it happened, those type of things. But that information must be done and given to the parent within 5 school days of the ESI occurring. It's imperative that that occurs. Now, if ESI has been used repetitively, on the 3rd time of using ESI or physical restraint, if the student has an IEP or 504 plan, those plans must be revised, may need to be revised, and a meeting must occur within 10 days of that last incident, of that 3rd incident. And parents have a right to appeal any use of ESI, and that's one of the documentation that must be sent to parents as their rights. If you have any questions on that, of what must be provided to a parents, contact your building administrator and they will assist you with getting all that information together, or the central office administration. Then along with ESI, there's certain requirements that must be made to the state. Those state notifications are completed by the building administrator with the assistance of central office administration. Okay, so we're in our final section here of this presentation, talking about bloodborne pathogens. Bloodborne pathogens. What are bloodborne pathogens? They're infectious microorganisms in human blood that can cause disease in humans. And bloodborne actually means carried by blood. And it's diseases that are spread through blood and other infectious bodily fluids. And what we're going to talk about today specifically, just quickly, is hepatitis B and C and HIV. Now, hepatitis is a liver disease, and actually it goes all the way something from like hepatitis A, I think, through F or K. But today we're only going to talk about B and C. And hepatitis B is spread through contact with infected blood, semen, vaginal fluids, and sometimes saliva. And it's spread mainly through unprotected sex, needle sharing, or from a mother to her baby at birth. It can also be spread through bites that break the skin. Now, there have been documented cases of hepatitis B spread through sharing a toothbrush or razor with an infected individual, but those are very rare. Now, hepatitis C, similarly, is spread mainly through contact with infected blood. Okay, most common and most likely method of transmitting hepatitis C are needle sharing and exposure to infected blood. Hepatitis is not spread through casual contact, so the likelihood of becoming infected in a school setting is relatively low. However, both Hep C and B can be spread through direct exposure of non-intact skin, such as rashes, cuts, those types of things, abrasions, with infected bodily fluids. Now, the hepatitis B virus can remain alive and an infection outside the body for up to 1 week, even in dried blood, so the blood doesn't have to be fresh. Now, infection with either hepatitis B or C may cause no symptoms for some time, and in fact, a person infected with hepatitis C may have no symptoms for decades. And if the symptoms do occur, they're the following: nausea and vomiting, jaundice, muscle and joint pain, and fever, and that's both for B and C. Now, there are medications that can treat the symptoms of hepatitis B and C, but there's no cure for either viral infection. There is a preventative vaccine for hepatitis B, however. Let's move on to HIV. Now, HIV, as I'm sure most of you are well aware, is the virus that causes AIDS, and it's spread through the contact of blood, semen, vaginal fluids, and breast milk. HIV, again, similar to hepatitis, is not spread through casual contact. So likelihood of becoming infected in a school setting, again, is relatively low. However, similarly to hepatitis, it can be spread through direct exposure of non-intact skin, so rashes, cuts, but again, only with other infected body fluids. There is no cure for HIV or AIDS, but there are medications available which may slow the progression of the virus. Now, with HIV, there are very few symptoms, and some people will not have symptoms for years. Some people have a brief kind of flu-like illness shortly after being infected, but again, people may never know for years that they're infected. But when symptoms do occur, they include the following: swollen lymph glands, weight loss, night sweats, and chronic diarrhea. Thank you again for taking the time to spend with us to review the policies of the district. We really firmly believe that these policies and these practices make your employment environment a safe and professional one so that you can succeed and that the students can succeed. Again, if you have any questions about these policies, feel free to contact your building administrator or central office administration. Also, I strongly encourage you to review all of the district policies located on the district's intranet website. And if you need a hard copy of those, you can always feel free to contact district central office. Hope you have a wonderful school year.